Okay, we're on the record in the matter of the People versus Richard Galt. This is file number 244943. The record should reflect Mr. Galt is present today here in the courtroom. If I can have counsel put your appearances on.
Your Honor, Ryan Ziegler on behalf of the people.
Good morning. Thank you, Albert. Gordon Murphy on behalf of Mr. Galt. He's just seated to my left.
All right, thank you. We're on the record today for hearing on a number of different motions that have been filed by both sides in this case. I've had a chance to go through the briefs and all the supporting documentation that was submitted with those motions. I've got really no particular order other than I think that we should address the motion regarding the search warrant first, since a lot of the other motions involve claims related to that. So, Mr. Gurmurthy, that's your motion. Is there anything that you wanted to present today by way of oral argument besides what was in your written brief?
No, Judge, what's in my written brief supports what I would argue orally. So I would ask the court to rule based on the written pleadings that we submitted. I think there were, the search warrant was submitted as well, indicating the issue that we raised with the 84th and the 87th District Court search warrant issues. So I will leave that up to the court to rule.
All right, thank you. Mr. Ziegler.
Your Honor, I think the motions largely contain all the arguments I would make. The search warrants at issue are attached. We had discussed in chambers that the court feels comfortable without the taking of additional testimony at the point, simply establishing that those are the search warrants at issue. So I feel like the court has sufficient information to rule.
Okay, so again, I did review the motion. The motion involves kind of mixed arguments regarding procedural. Yes, Mr. Gall.
Your Honor, may I present this to the court right here? It's a document authored by Mr. Detective Sergeant Brett Nichols.
Sure. You want to hand that to the.
Here, I have a copy for Mr. Ziegler too. Look at this document, Your Honor. It states that on October 30th, 2023 at 4:00 p.m. authored by Detective Sergeant Nichols, the affidavit and search warrant were drafted and sworn to and signed by Detective Sergeant Brett Nichols on October 30th, 2023. Search warrant was approved and signed by 87B District Court, Kalkaska County Magistrate Melina Wiper. Now, if you look down here at executive search warrant, says the search warrant was fully executed on October 30th, 2023 at approximately 4 p.m. So the search was fully executed at 4:00 p.m. before Detective Sergeant Nichols even drafted the affidavit in the search warrant, which coincides with the testimony from Detective Guzikowski on the stand at the preliminary exam was that he did not have a search warrant at the time he personally executed the search of the residence, and a search warrant was generated later. This sworn testimony under oath by the officer that personally executed the search of the residence. There was not a search warrant at the time of the search. One was generated later. And this document just goes as proof, authored by Detective Sergeant Nichols, that the search was fully executed before the search warrant and the affidavit and the search warrant were even drafted.
Okay, Mr. Ziegler, any response to that?
Yeah, it's simply not what the document says. At the top under search warrant, it says the affidavit and search warrant were drafted, sworn to and signed by Detective Sergeant Brett Nichols on October 30th, that then went to the property and executed that search warrant. This is referencing the first search warrant of the three. And so that search warrant was in hand. The whole point of going to the property was to execute the search warrant. They had no other reason to be there. There was not an arrest warrant at that time. They weren't going there without lawful authority. There'd simply be no reason for them to be there unless they already had that search warrant in hand. So it's just simply not factually accurate. The court requires testimony on that point. Detective Nichols is here.
Okay.
Your Honor, again, I have to go back to the preliminary exam transcripts by Detective Guzikowski that testified on the stand under oath that he personally executed the search of the residence and he did not have a search warrant. One was generated later. Sworn testimony from the officer that personally executed the search.
Your Honor, the warrant can't be executed unless it already exists. So the language in the report is quite clear. The search warrant was fully executed. You can't execute a search warrant if you don't already have a search warrant. So I don't understand it.
All right. I will take that argument into consideration, Mr. Galt. One thing that we need to get clear before we go much further here is this is not a tag team event
I understand.
where you and your lawyer both argue to me.
I understand.
So you need to make a decision about whether you want to represent yourself and make arguments on your own behalf, or whether you want to have an attorney represent you, but it can't be a combination of both.
Right.
So I need you to make that decision right now, because I'm not going to have Mr. Gurmurthy make arguments today, and then you make arguments, and then have the prosecutor respond.
Well, see, this is the issue, Your Honor, is Mr. Gurmurthy and I are basically a team. And also, nobody knows my case better than I do, because I've been locked up for 15 months. And I've done nothing but read through this report over and over and over and over again. You know what I mean? And plus, you know, I met with Mr. Gurmurthy one time in person in the last 6 months. And I've spoke with him personally for a total of 4 hours in the past 6 months.
Yeah.
So, I mean, again, I know my case better than anybody, and, you know.
Okay, none of that changes the fact that as a matter of courtroom procedure, I'm not going to have two people arguing motions to me.
I understand.
So I understand everything that you're saying. Mr. Gurmurthy is here as the person to present your arguments on your behalf. So to the extent that you want things raised, then you need to communicate that to him, and he's the one that communicates that to the court. Unless you want to represent yourself, and then you're the one who can present those arguments, but it can't be both of you at the same time.
I'll simply state, Judge, that those arguments were in our written response. That was raised, we've raised that with the trooper's testimony and what he testified to at the prelim. And the prelim's transcripts are part of the record. And I'm sure the court has a copy and has read it.
Right.
So again, to the extent Mr. Gall needs to argue that Gutkowski's testimony is part of the record.
So I need some clear direction from you here, Mr. Galt, right now, as to whether you want to represent yourself and you want to make arguments today, or whether you want to have Mr. Gurmurthy represent you, because your answer is going to give me the direction about who is going to be speaking today from your table.
I want Mr. Gurmurthy to represent me, Your Honor, but I just ask that he presents the courts with the documents that I have presented with him, as well as the ones that I brought today.
Well, again, that's between you and him. And if you want to speak with them during the course of the hearings today, I'll give you an opportunity to do that. But
okay,
that's like you said, you guys are the team there. You need to figure out between the two of you how you want to go forward. Okay. All right. So Mr. Gurmurthy will be presenting all the arguments here today. And that's how we'll go forward. I will certainly take into consideration, and I agree with counsel, this is something that wasn't raised in Mr. Gurmurthy's brief. And I think, you know, in light of that challenge, maybe we do need to take some testimony on that point, Mr. Ziegler. So in terms of, I think the allegation here is that at the time that they went to Mr. Galt's residence, that they did not actually have a search warrant that had been signed and approved by a magistrate, so that the search would have been improper.
I called Detective Nichols.
Okay, Detective, come forward, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you. Seated, and please state your first and last name for the record.
Yeah, my first name is Brett, B-R-E-T-T. My last name is Nichols.
Please proceed.
Thank you, Your Honor. Detective Nichols, what is your occupation?
Detective Sergeant with Michigan State Police,
How long have you worked in law enforcement?
25 years.
Were you on duty on October 27th, 2023?
Yes, I was.
Did you become involved in an investigation related to the death of Jessica Scott?
I did.
And did that investigation lead you to a particular suspect in the following days?
Yes, I did.
Who was that?
Richard Gall.
And do you recall seeking a search warrant on October 30th, 2023?
Yes, I did.
About what time of day was that, if you recall?
It was in the morning.
And where was that search warrant? What place was that designed to search?
Mr. Galt's residence on Cunningham,
And what led you to believe that that was Mr. Galt's residence?
through interviews with family of the victim.
And at the time you were drafting that search warrant, did you have any reason to believe that firearms would be located in the residence?
Yes, I did.
What was that reason?
I was told by family members of the victim, Jessica Scott, that they had personally seen firearms in the residence.
I may approach, Your Honor.
Yes.
I do have marked as People's Exhibit 1. Do you recognize this document?
Yes, I did.
What do you recognize it as?
A search warrant that I drafted for the residence.
This was the one that was drafted the morning of October 30th, 2023.
Yes.
And Your Honor, just for the record, Mr. Drummer, is bringing to my attention. In my brief, this is the same search warrant that's marked as Exhibit A. In my brief, I'm marking it as Exhibit 1 on the record. I don't know if the court wants me to keep the labeling consistent or if it matters.
It might be easier, yeah, if we keep it consistent, so we use the letter.
So for the record, I'm relabeling People's Exhibit, proposed Exhibit 1 as People's proposed Exhibit A.
Okay, thank you.
Did you swear to that search warrant in front of a magistrate?
Yes, I did.
And did the magistrate sign that search warrant?
Yes.
What happened after that search warrant was signed?
Eventually, later in that day, the search warrant was executed at the residence.
So that would be at 8324 Cunningham Road.
Yes.
Do you know a Detective Grant Guzikowski?
Yes, I did.
How do you know him?
I worked with him.
Was he on scene that day as well?
Yes.
Was Mr. Galt arrested that day?
Yes, he was.
How did that come about?
Mr. Galt came out of the residence wearing body armor. It was known that Mr. Galt was a felon, and it is a crime for a felon to be in possession of body armor.
So just to make sure the court is clear on this point, when you went to the residence that day, what was your purpose in going to the residence on Cunningham Road?
To execute the search warrant.
Did you have an arrest warrant for Mr. Galt at that time?
I did not.
And there were other officers present to assist you in executing that search warrant?
Yes.
When you made your presence known, did Mr. Galt immediately exit the residence?
No, he did not.
How long was law enforcement present before he exited?
I believe it was 45 minutes to an hour.
And what efforts were made to get Mr. Galt to exit the residence?
Several phone calls to him from myself, from Detective Sergeant Guzikowski, and also from his daughter Sterling. We had our emergency services team that was there also making a lot of noise in his yard and making announcements over the PA system.
You said eventually he exited in body armor and was arrested.
Yes.
At that point, was that search warrant executed?
Yes, it was.
Did you execute that warrant or did other officers execute it?
Other officers did.
Do you know whether any firearms were seized as a result of that search warrant?
Yes, there were.
Do you know if any electronic devices were seized as a result of that search warrant?
Yes.
And then were there subsequently did Detective Guzikowski prepare a warrant to search the electronic data?
Yes.
I don't know if we want to get into the second and third warrants or if that's sufficient to address the court's question.
That's sufficient for what I needed to hear.
So I have no further questions. then,
We'll
Your Honor.
see what happens with Mr. Murphy's process in here.
I just have a couple of questions. I was looking, so, at what time was the search warrant executed or sworn to by you in front of the magistrate?
The exact time I don't know. It was done in the morning on October 30th.
So 9, 10, just the time frame, approximately.
Before lunch.
Okay. And what time was the search warrant then executed?
I believe we got out to the residence 2:15 or 3:15 or so.
That would be in the afternoon after
In the
lunch.
afternoon, yes.
And at that point, did the Trooper Gutkowski have a copy of the warrant in his possession?
I don't know if he had one in his possession. He was shown one. And they were given a copy of the search warrant to leave in the residence. Mr. Galt was given a copy of the warrant.
So when the document that Mr. Galt provided to the court and yourself indicates that there was a warrant that was signed or drafted and then fully executed,
Correct.
Can
If
you
I can
explain
make-
that?
Yes, in fact, there are two complaint numbers that Mr. Galt is looking at. The original complaint number that we took for regarding Ms. Galt's death is 2372. The complaint number was later pulled that afternoon after the firearms were located at his residence. That is a 2394 complaint number. That complaint number was pulled in the afternoon of October 30th after the firearms were located to open a separate investigation.
So at the time the search warrant was drafted in the morning, firearms were not part of that original search warrant.
They were, the firearms were listed in that search warrant as part of what we were looking for.
All right, once the firearms were found, a separate complaint was then generated for a separate firearms investigation.
Correct.
I don't have any further questions, Judge.
Any follow up? Okay, thank you, Detective Sergeant Nichols, you can step down. Mr. Sigler, any further argument that you wanted to present on the motion regarding the search warrant?
No, Your Honor, I will just provide the court with a copy of the.
Mr. Gurmurthy, any rebuttal argument?
No,
Okay. All right, so.
I would still just lay on my written briefs and rest on those.
All right, so again, the court reviewed the documents submitted by the parties, including each of the 3 search warrants in this case. And just looking at the law, and again, there's mixed questions here, both the procedure, in other words, were they properly executed? I'm sorry, were they properly drafted and signed, proper authorization by the magistrate? Were they effective, going to the claim of the jurisdictional issue based on the November 3rd search warrant? And then matters of substance, in other words, did the search exceed the scope of the search warrant itself, such that the items found should be suppressed or inadmissible as proof of a poisonous tree. So looking at the law regarding search warrants, reviewing courts and looking at search warrants have to determine whether or not a reasonably cautious person could have concluded that there was a substantial basis for finding probable cause to issue a search warrant. The reviewing court must afford deference to the magistrate's decision and ensure that there's a substantial basis for the magistrate's conclusion, that there is a fair probability that contraband or other evidence of a crime will be found in that particular place. Affidavits for search warrants have to be interpreted by reviewing courts in a common sense and realistic fashion. They're normally drafted by non-lawyers in the midst and haste of a criminal investigation, and therefore technical requirements of elaborate specificity that has previously been required under common law has no place in the reviewing of search warrants under the law as it's been interpreted. A grudging or negative attitude by reviewing courts towards warrants will tend to discourage police officers from submitting their evidence to a judicial officer before acting, and so that's the basis for the deference that's provided by reviewing courts. In terms of the content and specificity of search warrants, the place to be searched has to be described with sufficient precision so as to exclude any and all other places. In other words, if a multi-unit dwelling is involved, the warrant has to specify exactly which subunit is to be searched. It can't be general. It can't be open to interpretation and allow for police to search places that they would not be authorized to search. The places and persons to be searched by warrant have to be described sufficiently to identify them with reasonable certainty, so that the object of the search is not left in the officer's discretion. In other words, the description in the search warrant can't be so general that police can just conduct a wide-ranging fishing expedition of any places or things located where the search warrant provides. And again, the purpose of that particularization is to describe the items, describe the place, to provide reasonable guidance to the officers, and to prevent the exercise of unlimited or undirected discretion determining what can be searched and what can be seized. And the degree of that specificity, of course, depends on the circumstances of each case. Here, first looking at the search warrant that was issued on October 30th of 2023, Officer Nichols is the officer who submitted the affidavit, signed that affidavit to the magistrate. Officer Nichols has testified here today that he did that early in the day of October 30th, and that search warrant had been signed by the magistrate prior to the execution of that search warrant. So whether or not Detective Gosakowski had one in his physical possession at the time, he was aware, based on Officer or Detective Nichols' testimony, that there had been a search warrant issued. Officer Nichols certainly had possession of that search warrant prior to the search. So if the court finds any argument that there hadn't been a valid search warrant in place prior to the search, it's not supported by the evidence. Looking at the search warrant itself in terms of its description, first of the residence and property, it lists the address, it lists latitude and longitude coordinates. It sufficiently describes the appearance of that residence, to the extent, again, under the review that the court is to conduct, to the extent that police could not be mistaken about where they were searching. It could not lead the police to search a place that wasn't the subject of the investigation. So the court finds that the description of the place to be searched was sufficiently particular to be valid. In terms of the description of the types of things to be searched for, well, the last sentence under property to be searched in paragraph 2 does discuss evidence related to domestic violence or assault and battery within the residence. It's clearly not limited to only items that would relate to that type of crime. There are many things listed prior to that, and so it's clear to me, I think just based on a common sense reading paragraph 2, that the police were authorized to search and seize all those different types of items, not only those relating to domestic violence or assault and battery, but in addition to those things related to domestic violence or assault and battery. So the domestic violence part of that is just one category of the types of items that police were authorized to search and to seize. The other things that are listed, such as video recordings, surveillance devices, cameras, DVDs, digital recorders, devices capable of storing audio or video recordings, such as phones, clothing, bedding, fingerprints, hair, blood, other bodily fluids, DNA, swabs, trace evidence, firearms, ammunition, mobile phones. All those things that are listed are all things that could be reasonably related to the crime which was being investigated, which was the death of the victim in this case. So those items, I think, are specific items. They're listed. That they all relate to either the crime of domestic violence or assault or a crime of murder. And it's not unlimited or left up solely to the discretion of the officers. And so the court finds that that warrant of October 30th is not invalid, did not exceed the scope. The court reviewed the return of the warrant and the inventory of the items that were seized. Every item that was seized was an item that was listed in paragraph 2 as property to be searched and seized. So the police did not seize things that were outside the scope. So the court finds that there's nothing improper about the October 30th warrant, and that anything found as a result of that should not be suppressed. There's also a challenge to the November 3rd warrant and the later warrant correcting the November 3rd warrant, addressing some of the typos, which in my view, in looking at that, clearly were typographical errors. The jurisdictional issue of the 84th district versus the 87th district. Obviously, even though it says 84th, it was clearly signed in the 87th district by an 87th district magistrate. It was executed within that jurisdiction. So the court finds that from a procedural standpoint, everything was correct, other than the court that was listed on the face sheet of the warrant and affidavit. So nothing about that invalidates the authority of the magistrate to issue that search warrant. Nothing invalidates the officer's sworn testimony through the affidavit to the facts that would support that search warrant. And it was ultimately documented regarding the mistakes and a new search warrant was drafted. Nothing about the changes prevented the second search warrant from being approved by the magistrate. To the extent that there were substantive mistakes in there, again, those mistakes were documented. A new search warrant was applied for and was issued. So even though it was after the fact, the magistrate found that there was justification to issue the search warrant. Even looking at the substance itself, the general nature of the crimes that were in the November 3rd warrant versus the corrected warrant are similar. They both would support, number one, the searching of that residence, and number two, the searching of and seizing of the particular items. And of course, that one related more to the searching of the phone, which similarly would have been supported by the facts. So the court finds that the typographical errors, even to the extent that they go to the substance of the warrant, do not invalidate the warrant, and therefore any of the evidence seized as a result of the November 3rd warrant is also not invalidated and suppressed. So the court will deny that motion. Moving on to the next one, the court would like to address the people's notice of intent to introduce evidence of prior acts of domestic violence. Because the people provided the notice of that and challenged it. You have any additional argument that you'd like to present on that?
I would just rely on my written responses, and I would again just highlight that 2 out of the 3 convictions are over 10 years old. The last one is 9 years old again. I don't think the argument that it's being used for propensity meets the muster of what the law requires and the factors that I've cited in case law. So I would just rely on that, Judge.
Mr. Ziegler, are the people seeking which prior acts are you attempting to introduce evidence beyond the 10-year?
I am, Your Honor.
Okay. So any argument that you want to make in support of the introduction of those?
Your Honor, did the court receive and review my reply brief?
I did.
On that issue? Then I think that addresses all the issues I had with Mr. Murphy's response. So I would just rely on that. I think they're all highly relevant to show the defendant's course of conduct, the fact that he has done this repeatedly over the course of his life, and it goes to show that he's the perpetrator of the alleged offense in this case. Even if those things fall outside the 10 years, I think they're uniquely probative in this case. So other than that, I would rely on my briefing, Your Honor.
Okay. All right. Looking at the law that applies, and again, I did review the briefs of the parties. Looking at the law that applies to the admission of evidence pursuant to 768.27b. That statute does allow evidence that a defendant committed other acts of domestic violence to be admitted for any purpose for which it would be relevant, unless it's not otherwise excluded under MRE 403. That is generally limited to incidents that did not take place more than 10 years before the charged offense. And it doesn't limit or preclude the reasons for which that evidence could be used as long as it's relevant. And that includes for the purpose of showing propensity, which is of course a broader use of that type of evidence than is typically allowed under MRE 404B. The only exception to that 10-year rule that would be applicable in this case is that it would be in the interest of justice. When making determinations that evidence of domestic violence acts further in time than 10 years, the court has to construe that exception very narrowly, and it's only admissible under the interest of justice exception if that evidence is uniquely probative or if the jury is likely to be misled without the admission of that evidence. Offenses involving domestic violence in the court, in terms of the arguments raised by counsel, the court is looking in particular at the statutory language, and it doesn't limit the admission of that evidence to offenses of domestic violence. It specifically states offenses involving domestic violence. So it's not limited to only prior actual charges of domestic violence, or I'm sorry, the offense involved does not have to be a domestic violence offense. It only has to be an offense that involves domestic violence. It's defined domestic violence in different ways, in different statutes. However, under 768.27B6A, an offense involving domestic violence means the occurrence of any of the following acts by an individual that is not an act of self-defense: causing or attempting to cause physical or mental harm to a family or household member, placing a family or household member in fear of physical harm or mental harm, causing or attempting to cause a family or household member to engage in involuntary sexual activity by force, threat of force, or duress, or engaging in activity toward a family or household member that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested. So as long as the conduct in this case involved any of those types of conduct, the charged offense does not have to be a domestic violence offense. And in this case, the court finds that clearly the charged offense of second-degree murder is an offense under the facts in this case involving domestic violence. So the court finds that that would not be a reason not to admit. So the court finds that the crime of second-degree murder does meet the definition of an offense involving domestic violence under the facts of this case, and therefore certainly any of the acts that occurred within 10 years would be admissible for any purposes that they're relevant, including to show propensity. That's not the end of the analysis. The court has to also look at whether or not that omission of that type of evidence would be unfairly prejudicial or otherwise inadmissible under MRA 403. The concept of unfair prejudice does not mean damaging. Any relevant testimony is going to be damaging to some extent. The idea of unfair prejudice encompasses two concepts. First, the idea that prejudice denotes a situation in which there exists a danger that only marginally probative evidence would be given undue or preemptive weight by a jury. In other words, where that evidence is only minimally damaging in terms of its logical relevance, a jury would give it much more weight than it actually deserves, and make it more damaging than it should be from a logical standpoint. And that can lead to the potential for unfair prejudice. And second, whether or not it would just be unfair generally to allow the proponent to have a jury hear that evidence. In this case, because this case is primarily based on circumstantial evidence, the defendant's propensity to commit acts of domestic violence, in my view, is much more than marginally probative as to whether he did that in this case, to the extent that it caused the death of the victim. So the court finds this is not a circumstance where this is marginally probative evidence that could be given undue weight by a jury. I find this evidence to be extremely probative because of the similarity in the facts of this crime to prior acts of domestic violence. I also think it would be probative as to identity, that it was the defendant who committed this crime. So the court finds that it would not be unfair or unduly prejudicial to allow evidence of at least the conviction that occurred within the appropriate time frame. In terms of the convictions prior to the 10-year statutory limitation, the court finds that although the acts of domestic violence prior to that are certainly probative, and on the issue of propensity, the court can't find that they should be admissible, again, because primarily as time passes and the further back in time that those prior situations are, the less probative they become in terms of the defendant's actions in this case. So the court finds that the exception does not apply in this case. I don't think that it's uniquely probative or that the jury would be misled without the admission of that evidence. So the court is going to deny the objection to the extent that the people are seeking to admit prior acts of domestic violence more than 10 years in the past. The court is denying the objection to the extent that any acts of domestic violence within 10 years are admissible, and so the court will allow those at the time of trial. The next motion is the people's motion in limine to admit certain statements by the victim in this case. There are 3 categories of those statements, and correct me if I'm wrong, Mr. Ziegler, but there's the statements that were made to the 911 operator during that call. There are statements that were made to EMS when they arrived on the scene, and to Miss Boyd, the nurse at Kalkaska. And then there are text messages to Miss Yeomans, who is the victim's sister. Are those the categories that you're seeking to admit?
That's correct, yeah.
Okay. Any argument that you would like to present on those issues?
Your Honor, I think all of those items, if I'm not mistaken, were admitted at the preliminary exam. The reasons why they were admitted are part of the record. I think my brief adequately addresses the legal arguments regarding which exceptions apply, the fact that they're non-testimonial, the fact that it's uniquely probative in this case because the victim is deceased and can't take the stand and speak for herself. So I think all of that is well covered in my motion in the preliminary exam transcript. Unless the court has any questions, I would ask the court to rule based on briefing.
I do not, Mr. Gerber.
Just, we responded as to why we don't believe they meet, what the exceptions are, why they're not admissible statements. Again, I've addressed the issue that they were, again, not statements that were made in contemplation of death, were not for medical purposes. We argued that the preliminary exam as well. So, we're set to go to trial. I think we need a more clear direction here with the court. Again, the veracity of those text messages and the authenticity were challenged at the prelim. So again, we've argued that in our written brief. So I'll just rely back on our written brief.
All right, thank you. First of all, whether or not to admit or exclude evidence is within the discretion of the trial court. I'm certainly acting within the exercise of that discretion and ruling on this motion. Looking at the first category of statements by the victim in this case, those to the 911 operator, the people are seeking to admit that under the excited utterance exception of MRE 8032. Parties properly cited the law as to that. In order for those kind of statements to be admissible, they must arise out of a startling occasion. They must be made before there's been time to contrive or misrepresent, and it must relate to the circumstances of the startling occasion. Looking a little more in depth into those requirements, case law states that it's the lack of the capacity to fabricate, not the lack of time to fabricate, that's the focus of the excited utterance rule. The question is not strictly one of time, but of the possibility for conscious reflection. Although the time between the event and the statement is an important factor to consider, it's not dispositive, and the court should determine if there's a good reason for the delay and some plausible reasons that case law found to excuse delays in time to allow those kind of statements are things like shock, unconsciousness, or pain. In this case, the court finds that those statements to the 911 operator are admissible. There's testimony in the record that she appeared to be in distress and in pain at the time that she was making that call. I think from the totality of the circumstances, it's reasonable to infer that the victim was clearly still under the stress of the alleged incidents with the defendant. And regardless of the time frame, I think the evidence is clear that she was in medical distress given what happened shortly after she was given medical or attempted to be given medical attention. In fact, that she passed away, but also indicates that at the time she made that call, she was in pain and seeking emergency medical attention. And so again, looking at this from the idea of did she have the capacity to fabricate those statements at the time, did she have had the presence of mind to do that, the court finds that given her medical situation, She was not. She was not in a position to fabricate those statements due to her physical and mental state. And the lack of that capacity to fabricate, to me, is sufficient indicia of trustworthiness of those statements, which is the whole idea behind these kind of exceptions. So the court finds that those statements are admissible under 803(2). The second category of statements are those that were made to EMS when they arrived and to the nurse Boyd. Those are offered also under the excited utterance exception of 803(2), but also under the exception under 803(4) for that they are statements given for purposes of medical treatment. In my view, that fits under these circumstances more than the excited utterance exception, although I think for many of the same reasons that I just gave, it certainly could be admissible under 803(2). But I think 803(4) more accurately fits the circumstances of these statements. Statements under 803(4) are admissible when they're made for and reasonably necessary to medical treatment or diagnosis in connection with that treatment. And those statements describe medical history, past or present symptoms or sensations, their inception, or their general cause. Traditionally, the supporting rationale for 803(4) statements to be admitted are the existence of the self-interested motivation to speak the truth to treating physicians so that the person can receive proper medical care, and the reasonable necessity of those the diagnosis and treatment of the patient. I think, in my view, looking at these statements, they were clearly given to aid the medical personnel in this in the treatment of her condition. In order to understand the victim's injuries in this case, how they were inflicted or the general cause would be crucial to the diagnosis. In other words, the fact that these injuries or her symptoms resulted from an assault as opposed to an accident or some type of underlying disease, I think it was crucial that the victim made those statements so that she could be accurately diagnosed and treated. So I think there's certainly a necessity for her to make those statements to get proper treatment. And I think under the circumstances, she certainly had the motivation in her own self-interest to tell them how it happened so that they could more quickly diagnose and treat her. Unfortunately, they weren't able to do so in this case. I think it's also notable that as part of those statements, none of them are identification of the defendant specifically. There is case law that indicates that to the extent statements are given for the purpose of medical treatment and they do identify an assailant, the identification may not be admissible because that doesn't go to medical treatment. In other words, who did it doesn't matter as much as how it happened. But reviewing her statements that the prosecutor is seeking to admit, none of them include an identification specifically of the defendant in this case. So for all those reasons, the court finds that, again, there is sufficient indicia of trustworthiness of these statements because of the reasons that they were given, for which the court will allow the admission of those statements at trial. The final category are the text messages to Ms. Yeomans. The people are seeking to admit that either under the excited utterance rule or the residual exception. First of all, the court finds that they are admissible under MRE 803(2) as excited utterances. Again, when I reviewed those statements, they're clearly arising out of the circumstances of the victim being beaten, in this case, being injured. There's clearly an urgency, in my view, in reading those messages behind them, which again, I think leads to a reasonable conclusion that she was still under the influence of a startling occasion that is being continuously abused, assaulted. And again, I think under those circumstances, these are not things where the victim would have had time to think about this and say, I'm going to come up with a story and text these things to my sister for the purpose of fabrication. But rather, it's clear to me, just looking at those statements, like reasonable inferences that she wanted to get out of there, she wanted help, needed help at that time. So the court finds that they are admissible under the exception. So the court isn't going to make any kind of ruling with regard to whether they qualify under the residual exception. So the court finds that all of those statements are admissible at trial. Final motion, Mr. Gurmurthy, is your motion to quash. Is there anything that you wanted to state by way of oral argument for that motion today?
No, sir, I'll rely on my written brief and motion that I filed.
Mr. Ziegler.
Yeah, I think the preliminary exam transcript is quite clear. I'm sure the court has reviewed it, so I would just rely on my written briefing and what's contained in the preliminary exam transcript.
Okay, so I did review the briefs of the parties. I did review the preliminary exam transcript, the entirety of it, including all of the testimony. And while number one of the challenges to the bind over relates to the search warrant, the court's already ruled on that. So the court finds that the evidence contained within the preliminary exam transcript and the testimony that was given is all admissible testimony and was properly considered by the district judge in binding the case over for trial. So the court doesn't find that any of the testimony or evidence that was provided should be excluded. So I'm looking at the same evidence that the district court judge looked at. In making legal conclusions, of course, the court does look at legal conclusions of the district court on bind over de novo. I think I've done that. I've addressed the legal issues already in my rulings here today in terms of what evidence was considered. In terms of the factual conclusions or the district court's finding of probable cause based on the evidence, the court reviews that only for an abuse of discretion. As long as the district court's decision finding probable cause as to each count is within the range of reasonable and principled outcomes, then this court is not to substitute its judgment for that of the district court. But only if this court were to find there was an abuse of discretion and that the bind over was outside the range of reasonable and principled conclusions. Looking at the transcript as a whole and relying in large part on the portions that were cited by the prosecution in their brief, the court finds that there was not an abuse of discretion. Certainly there are plenty of questions of fact here that could be raised. That's the purpose of trial. The purpose of bind over is only a probable cause finding, that is that a crime was committed and that the defendant committed it. And I think certainly with regard to the weapons charges, there's sufficient evidence to support probable cause. And also with regard to the second degree murder. And again, I'm not going to go through specifically every piece of evidence, primarily because again, it's an abuse of discretion review, but I think the prosecutor accurately set forth, and again, I would rely on portions of the transcript set and evidence set forth by the prosecution in their brief as a basis for finding that there was not an abuse of discretion by the district judge. So the court will deny the motion to quash. So I think, Mr. Gurmurthy, does that address all of your motions?
It does.
Mr. Ziegler, all of yours?
It does, yeah.
So I would just ask that each of you prepare orders based on your respective motions to submit to the court, simply for the reasons stated on the record here today.
Well, I just make a suggestion. What if we had a one order addressing all the issues today instead of having?
And that would be fine if you want to come up with an order that's stipulated as to form. Only,
Yeah. I think it just keeps it cleaner with the motions that the people filed and responded to, and the motions that the defense raised and responded to. I think we can lay it out that way. It might be easy to just be in one order that way.
Right, okay. All right, Mr. Ziegler, anything else that we need to address for your side? Mr. Gurmurthy?
No.
All right, thank you. That's all for today. Mr. Seeger, I just need about 5 minutes or so, and then I'll be ready on your We're on the record in People versus Clifford McNamara, case number 244932. The record should reflect Mr. McNamara is present here in the courtroom today. If I can have counsel for your appearance.
Your Honor, Ryan Ziegler on behalf of the people.
Thomas Seeger on behalf of Mr. McNamara.
Thank you. We're on the record here today for two motions by the defense. First of all, I think we have a stipulation as to the admissibility of the prior instance of sexual contact.
That's correct. That's correct, Your Honor.
Okay, Mr. Seeger, is that?
Sure.
Okay. And then the other one, Mr. Seeger, is your motion related to, I guess, I don't know, potential filing of a false police report or false allegations that were made against Robert, who is the alleged victim in this case for
Yes, sir.
anything that you wanted to state for the record. I did read your motion. I did review the documents that you submitted along with it. And then as part of the other motion, I reviewed the transcript from the preliminary exam in this case. So with all of that, anything you wanted to say?
Your Honor, the only other additional thing I would say is to the extent that the court had reviewed the other report, it is kind of interesting to me, and I think it really is somewhat information that the jury should have relative to her disclosure about a firearm being utilized in an unrelated matter, wherein she says that the husband held her at gunpoint and then assaulted her daughter. Police subsequently went out there following the 911 call, did not find a firearm, which is very similar to this case as well. And so I'm generally, just as a generality, and there's a lot to it, I'm generally saying that it appears to me that it's a common scheme or plan that whenever she alleges that a firearm is involved, immediately law enforcement are out there doing something. And it, strangely, in that report, it's also talking about, and I'm not talking about prior sexual anything, but she's talking about somebody being on her Facebook account, which is a male, that precipitates a argument with her husband, such that her husband then pulls a shotgun on her and her daughter. So I can only assume that if there was some kind of indiscretion between Mr. McNamara and the complaining witness in the instant case, if the husband knew that, how badly that would turn out if just having somebody's some random guy on your Facebook account results in having a shotgun pulled on you. So assuming arguendo that it's not somehow a bad act, as Mr. Ziegler had stylized it in his brief, I would say that 401, 402, and 403 apply, and it's relevant, and it's something that the jury should at least consider. And it's not really for me or for Mr. Ziegler, or I guess to a greater degree, it's for the court to make a determination as to whether or not something's relevant. But the rules of evidence are somewhat inclusive. I think the jury should, be able to have all the relevant information that they need to make or have in order to render a fair and just decision. I think that all of that stuff is pretty relevant, at least if looking at it objectively. Your Honor, if I were on a jury, I would want that information. That would probably be meaningful to me, but that does not necessarily mean it's meaningful to the court or Mr. Ziegler. It just means that the jury should have the opportunity to inspect everything. And it's not that the burden changes or admissibility changes, but it is probably notable to say that he's the defendant in this case. She is not the defendant. He has the right to present a defense. And I think that it's a pretty crucial part for him to be able to do that.
Thank you. Mr. Ziegler?
Your Honor, largely I'm relying my briefing, but I think the most troublesome thing about Mr. Seeger's position in this case is that there's no ink spilled establishing that she actually made a false statement or what that false statement was. There's any number of reasons why a prosecutor might not want to proceed with the case, and it doesn't mean that she lied when she reported the crime, and it doesn't mean she made a false statement to law enforcement or to the prosecutor. Mr. Seeger is not putting before the court the statement that he's saying, this is a false statement. And then he wants to turn around and simply assume that because it was reported and not prosecuted, a false statement must have been made, and therefore he gets to impeach her with the fact that the case wasn't prosecuted. I don't think that's fair, Your Honor. At the very least, he needs to establish that she's made a statement and that that statement was false, or that it tended to show she's engaged in some kind of common scheme of dishonesty. The fact that she's reported 2 different crimes to law enforcement doesn't suggest a common scheme or plan to be dishonest to the police until he's established that the report was false, and it just hasn't happened. Even if it were the case that the report was false, as I laid out in my brief, I don't think it comes under 404B, because it's not, the 2 cases are not related to one another in any way, shape, or form, other than just the fact that a gun may or may not have been involved in each. That's not a common scheme or plan to defraud either this defendant or the defendant in the other case. It doesn't come in under 608 either, because the defense can't use extrinsic evidence under 608. And I don't think we should open the rabbit hole in any case under 403, simply because the defense has not made a sufficient showing that a false statement has been made. And we're going to spend a good chunk of this trial, should this come in, arguing about whether or not the statement was false in the first place. And I think it's incumbent on the defense to make that showing before we open that can of worms. So for those reasons, Your Honor, I would ask that it be excluded entirely under 403, or to the extent that the court permits it, I think the proper venue for it being admitted is MRE 613, which is merely impeachment of a witness with prior inconsistent statements. And if she denies certain facts about that case, I think that then opens the door to present that testimony. But that's the only way it would come in. Right? So I would ask the court to do it that way.
Any response, Mr. Senior?
Your Honor, and as I laid out in the brief, the gun, at least in my mind, is part of the common scheme or plan. I think it's suffice to say that if law enforcement were given some kind of lesser fact that didn't involve a firearm, they may not immediately respond, they may not take any action. But when you take it to the level of I've been assaulted with a firearm, either sexually or just with a general assault, I think that there's a heightened amount of effort put into doing an investigation. I don't know if the court's going to address this, Your Honor, but I have not, because I didn't know what the court's ruling was going to be, but I did not subpoena the prosecuting attorney from Manistee. I did not subpoena the officer from Manistee. I will do those things to the extent that the court gives me permission to do those things, because in part, Mr. Ziegler was asking to quash those things anyway. So I would ask for a general ruling relative to that, but to a lesser degree, first, I think that 404B applies. Second, if 404B does not apply, then I agree with Mr. Ziegler that 613 allows me to bring that evidence in. But then the question becomes how the documents themselves come in. I don't know specifically what her answer is going to be. It will probably be somewhat interesting. Strangely enough, she's not willing to talk to me at this time. And either is the brother, likewise, not willing to talk to me at this time. So it's difficult to discern what their testimony would be at trial. But I do have a lot of questions that I'm ready and prepared to ask them, very much along with the line of it's referenced in my briefs. I think that it's admissible. If the court says it is, then I will accordingly subpoena those people. If the court says that it's not, then I will not subpoena those people. But I will probably, at a minimum, subpoena the officer from Manistee for purposes of rebuttal at the very least. But I think that I get to call him in that case in chief.
Okay. So I think for me, one of the keys to this was really the victim's testimony, or the alleged victim in the preliminary exam. After reading that, there's a lot that doesn't make sense to me here. I think there's some credibility issues, certainly the whole relationship between her and this Clifford McNamara, the defendant in this case, that prior instance of sexual contact that the parties have agreed is admissible. Her description of the assault that's at issue in this case, and then how that plays into this whole incident that occurred in Manistee. I think under different circumstances, I would have been inclined to certainly deny the motion under 404B as part of this, but having read that transcript, I think there's enough there, in my view, enough of a doubt as to the alleged victim's credibility on some of these points that I think it's potentially admissible under 404B. I think certainly under 608 or 613, it could be admissible as well, depending, as we all know, on her testimony on the 613 issue. But under 608, you know, some of it may be admissible as impeachment. The qualification under 608 is if it's probative as to the witness's truthfulness or untruthfulness. Extrinsic evidence can be admitted, or evidence of a specific incident. So whether it's 404B, whether it's 608, I think the court would have to make some threshold determinations about whether or not this incident manistee is probative of the witnesses, complaining witness or alleged victim's truthfulness or untruthfulness. And certainly whether or not this is part of some kind of common scheme that she engages in. So all of that to say that I think I would need some testimony prior to trial from whoever it is that you would want to call to establish this, whether it's the prosecutor, whether that's the police officers that responded. I think we would need to set this for an evidentiary hearing so that I could take that testimony and make some threshold findings as to 404B, as to 608, and then, you know, I think of course 613 we would have that testimony preserved, and depending on how she would testify at trial, then those witnesses may be proper witnesses that you could call in your case in chief, or as rebuttal, or well, wouldn't be rebuttal from these. So, Mr. Seeger, I'm going to leave that ball in your court. I'm going to hold these rulings in abeyance pending the evidentiary hearing. I think that's something maybe an hour, 2 hours tops. I certainly would be willing to do it by Zoom if parties can stipulate to that.
I don't have any objection, and Your Honor, because the witnesses that theoretically I would call would be from Manistee, as long as Mr. Ziegler doesn't have a particular objection, I would ask them to appear by Zoom. If the court following the evidentiary hearing determines that they're, I can admit that pursuant to 404B, then I would ask the, well, clearly they would have to appear in that manner.
Right. So I'll leave that up to you, Mr. Seeger, to contact my office and get a date and notice that for hearing. And then we'll take some testimony, because I do want to hear what those witnesses would have to say about this Manistee incident so that I can determine how closely related it may be in terms of her actions and to the degree it's probative of her truthfulness or untruthfulness in this instance.
Thank you.
Okay. Anything further, Mr. Ziegler and Mr. Seeger? Any further today?
No, sir. They're not from me.
Thank you for your time.
I can reach out to Jennifer to find some dates, and I'll have to try and coordinate that with the prosecuting attorney and law enforcement.
Yeah.
But